Now that we know about the difference between IPRAC and IRL-PRAC, I'd like to talk to you for a few minutes about the notion of understanding what judges and justices do when they decide cases. How do they do it? Do they go to a blank blackboard and just start to imagine what the result is? Or do they have a blackboard that's filled with possible angles for deciding cases and filled with possible precedents and rules that they can use and different rights that they can choose in deciding those cases? I'd like to tell my students that what they're actually doing is they're solving constitutional puzzles, and they can develop for each case their own decision-making matrix. There are various places that they can go to choose various options to decide these cases. Now, one of the standard things we think about is they can come to the case with a certain jurisprudential approach, which we will discuss in a bit. Are they self-restraint jurists deferring to the legislature? Or are they activists who are interested in trying to reach out and make law? They have different jurisprudential judge-making approaches. But they also might have a general political ideology. Are we dealing with a person who is a liberal or progressive, a conservative, a moderate, or perhaps a libertarian? They don't like government regulation. Beyond this, one of the things that judges can do is they can go back in history and figure out, was there a time when this issue was important, and what did people do in that area? Now, there are different kinds of historians. You have people who are only looking at the founding period. We will talk about them later. They're called originalists. But you also have people who will look through time and try to find a solution that worked in the past and might work now. So they are historians on the Supreme Court or on the federal judiciary. But another approach that judges can use is they can be more political philosophers. What I'm going to do is I'm going to look at the Constitution or this issue as an evolving issue. So I have a living, evolving approach to my decision-making. How have different generations of judges or justices decided these cases in the past, and how have those decisions changed the nature of the Constitution or the reading of those laws? Beyond that, sometimes judges prefer to look at the text of the Constitution or the Bill of Rights or a specific law. They become textualists, and oftentimes they're asking, should there be a fixed, specific meaning to the words in that constitutional provision or in that law? So you're working from political ideology to jurisprudential approaches to historian or political philosopher, and possibly reading the text of the decision. It's at this point that judges or justices can give us an indication whether or not they value those precedents. Are they people who are going to decide in an incremental basis? This is what people have done in the past. I'm only going to do what they've done in the past, or I'm going to go just a little bit farther. I'm going to be an incrementalist. Or maybe that judge or justice in that specific case may choose to overturn those earlier precedents. So they will have a more synoptic approach, a more general and highly differentiating approach. If you look at the way that justices move in that area, you can begin to predict how willing they will be to change the direction of past law if they are not positively following past precedent, what's called stare decisis, S-T-A-R-E-D-E-C-I-S-I-S, to let the past precedent prevail. It's a Latin term. Beyond that, judges will use a combination of things that might get to their decision-making result. They could use the notion of federalism. What have states done in the past? They could use an international approach. What have we seen in other industrialized countries? What have other courts done? They could go to social sciences. Let's see what psychology tells us. Let's see what sociology tells us. Let's see what political science tells us. They could look at the notion of public policy. Let's look at what the consequences are for this decision. Let's look at how these decisions might change the way government is done or might change the nature of rights in this country. And the final thing that these judges could look at is something called the zeitgeist. Zeitgeist. It's a German term meaning what's the conventional will of the people? What does the public think? This is something that a Supreme Court justice named Benjamin Cardozo back in the 1930s wrote about. And he talked about trying to fit the new precedents, the new result, into what the American people thought the government should be doing, thought the court should be doing at that time. I mention all of these possible factors because when you are doing your analysis of cases, when you are trying to figure out the IPRAC, or, as I hopefully persuaded you, the IRL-PRAC, you need to break down where the judge is going to get the information that they need to build their opinion. And there are a couple of ways that they can do to write their opinion. One of the ways is to use a kind of deductive process. I'm going to start with a major premise, and I'm going to work my way down. What is this issue? What is this right? What has this right been in the past? What should this right be now? What will this right be in the future? I'm going to work from large propositions and get all the way down to my final decision. Or I can use an inductive approach. I can look at all of these different ways that you can solve constitutional puzzles, all of the pieces of the decision-making matrix, and I can find pieces of my answer. And then in the end, I can pick and choose from among these pieces to build the result I want, a kind of grassroots process to decision-making. I like to tell my students that the best way to analyze Supreme Court opinions is to brief it, to take notes on it, a legal brief, to take notes on it deductively, and then to look at it inductively. If you are looking at a Fourth Amendment case, Mapp versus Ohio, and trying to figure out how the Supreme Court extended the Fourth Amendment to the states, it's helpful to understand the varying cases on search and seizure and the right of privacy and the power of the police, and work deductively from the top to the bottom. Here's what the framers of the Fourth Amendment intended for the Fourth Amendment to mean, and here is the right of privacy that Dahl Mapp in Mapp v. Ohio should have. But it's also helpful to work inductively and to understand that the Fourth Amendment didn't apply to Ohio before Mapp v. Ohio and didn't apply to the other states. And so we need to know, what are the other states doing? And that's how the court really decides this case. They talk to us not only about the precedents and the larger theories of the Fourth Amendment, but then they start looking at what did California do in the last 15 or 17 years? And what do other states do? And how will this change federalism? And once they figure that out, they understand that they need to do more than just decide what does an unreasonable search and seizure mean. They need to explain to us how the exclusionary rule will work, how it will be possible for a Supreme Court decision to be offered that will allow for a defense attorney to say, since the police broke the rules, broke the law, violated the Constitution in conducting their search, then that evidence should be excluded from trial and cannot be used. It's the only way to make it fair to the defendant and to punish the police for what they've done. So in my opinion, understanding how this decision matrix can work and types of decision-making tools are added constantly to this decision matrix knowing how it works deductively and knowing how it works inductively is the best way to proceed in analyzing cases, and I think will help you understand it better.